The coins alert is used to summarize everything that is said in this movie. Also, don't forget to like and subscribe to my station to get more XRP news and news about cryptocurrencies in general. Look at this now. Ripple is now facing new legal problems from the US SEC appeal. Before we go any further, there is a new crypto airdrop going on Telegram right now. It will soon be over. Make sure that you take part in this airdrop. Just below the movie, there is a link. Do not miss this. Let's watch more of our movie. Recent developments in the probe into the XRP case have caused strong feelings in the cryptocurrency community. Phylon confirmed that the appeal that the U.S. Securities and Exchange Commission made against Ripple has been sent to the Second Circuit Court of Appeals. James Kay is a well-known lawyer. This formal call has started conversations among people who like XRP. There were talks aimed directly at Ripple, its CEO Brad Garlinghouse, and its co-founder Chris Larsson. A formal document from the U.S. Securities and Exchange Commission is all about the leaders of Ripple. In its most recent appeal, the U.S. Securities and Exchange Commission named Brad Garlinghouse and Chris Larsson as executives at Ripple. This shocked the cryptocurrency business. In the first case, the agency couldn't back up the claims it made against the two officials with proof. This new development comes after that. Not only that, but this happened not long after the Securities and Exchange Commission put out a notice of appeal. Since the Securities and Exchange Commission's most recent appeal talks about Ripple's on-demand funding technology have come up again. Some groups have asked if Odell's sales had anything to do with the claims made against Garlinghouse and Larsson. In an effort to be clear, Bill Morgan said that Odell's sales are a part of Ripple's business actions but have nothing to do with the claims made against the executives. Odell's sales are a part of what Ripple does for business. That being said, they were not part of the accusations made against some leaders. John Morgan Bill, at this point Stuart Alderode, Ripple's general counsel, brought up the idea of filing a cross-appeal in the case. A lot of people in the Bitcoin community have said bad things about what the SEC did, and the market is very interested in how this appeal turns out. Although the Securities and Exchange Commissions are going after leaders again, this could change the way the case goes and boost Ripple's defense systems. Because of recent events, people who own XRP may need to get ready for a longer court process. The Ripple community is paying close attention to the SEC's most recent move and trying to figure out why they did it and what their long-term goals are. Different people have different ideas about how to solve the problem. Depending on how the case turns out, the decision in this action could have big effects on the future of XRP and the cryptocurrency market. As shown by the notice of appeal that the Securities and Exchange Commission sent, the group plans to keep working on this case. For whatever reason, this process leaves room for a settlement during the 14 days that follow the warning. The appeal from the Securities and Exchange Commission (SEC) is called Vipol Labs, Inc. At this point, the United States Court of Appeals for the Second Circuit has given it the file number 242648. They are Brad Garlinghouse and Chris Larsson. Both of the leaders at Ripple have been named as respondents in this petition. There are always new changes happening in this situation. Even with this formal appeal, there is still no set date for the hearings. It has to do with the racist goals. There is a lot of guesswork in the world of cryptocurrencies. Throughout its history, the agency has had a hard time proving claims against top Ripple executives. A number of experts believe that this increased focus could mean that people are trying to look over old information and maybe go after claims that were thrown out earlier. Mark Svagel, who used to work as a lawyer for the Securities and Exchange Commission, says the organization should think again about choices it has already made. Supporters of the business are getting more and more angry, especially since Brad Garlinghouse is no longer directly involved in the lawsuit. If you remember, the Securities and Exchange Commission dropped a case against him in the past, which made people wonder what their current position is. Taking care of the unknowns in your life. Attorney Fred Rispoli looked at how likely it was that the Securities and Exchange Commission would win its case against Ripple. He thinks that Ripple has strong defenses. He does say, though, that the success of the case might depend on which group is given it. The group tends to agree with the government, which means that Rispoli warned that the SEC has a good chance of winning. Because we don't know for sure how future events will turn out. The people who use XRP need to be ready for anything that might happen. The stakes are still very high in this case because it could change how coins are regulated. A tweet from Not long ago by Stuart Alderode, Ripple's chief legal officer, called attention to a big legal precedent. He did this by mentioning the case that the Second Circuit Court of Appeals decided. Some of the most important parts of the court's ruling were used in his essay. Some of these comments were, "We don't agree with the SEC, we are not persuaded, and the SEC's counterarguments are not convincing," this statement. indirectly shows how confident Ripple is in its legal battle with the SEC. It talks about how the court didn't agree with the SEC's arguments in cases brought before the SEC, the impact of the government's ruling on disgorgement, in particular the decision made by the Second Circuit in the Govil case is important because it further limits the Securities and Exchange Commission's power, mostly when it comes to how it can use disgorgement as a punishment. As in the case of Govil, the court did not agree with the SEC's request for disgorgement because there was no proof that buyers had lost money. This decision is based on the Supreme Court's decision in Louis SEC 2020, which says that disgorgement can be paid directly to people who have been hurt by hypothetical harm. The court's ruling in Govil can now be used as a key example by Ripple's lawyers in their case against the Securities and Exchange Commission. As part of Ripple's arguments against calling XRP a security, Alderati draws a link between the Govil decision and the problem that Ripple and his tweet are still having. You may remember that Ripple has been fighting the SEC's choice to label its XRP coin as a security for a very long time. The business has said that the SEC's way is both inconsistent and too broad. Through bringing up the fact that the appeal court threw out the SEC's points in Govil, Alderati shows that he is sure that the SEC's case against Ripple will be thrown out in the same way. His views are similar to those of many people in the Bitcoin community who think that the SEC's actions are too cruel and go against the law. Another thing to think about is that the court's criticism of Sextus's counter-arguments in the Govil case could be seen as a sign of the bigger legal conflict in the cryptocurrency field. Legal battles have been going on for a long time because Ripple and other players in the industry have kept saying that the Securities and Exchange Commission controls digital assets using old rules for securities. The information given is not meant to be taken as trade advice. Any purchases made based on the information on this page are not the responsibility of the people who made them. Before making any investment decisions, you should definitely do your own study and talk to a professional who knows what they're talking about.